In today's video, I'm going to talk about the application for and the requirements of a search warrant. It might surprise you to learn that there's over 175 different statutory provisions for a search warrant. The most commonly known is that under Section 8 of the Police and Criminal Evidence Act of 1984, commonly known as PACE. Section 8, of course, provides a fairly general power to search. Others might be very much more specific, such as searching for stolen items, drugs, prohibited articles, firearms, and so on. Search warrants are issued by magistrates or judges, and there are around 40,000 of them issued each year. There can be many issues with the warrant or the application itself, and there have been lots of consultations on reforming the law and making changes to make it more understandable and more consistent. I will say at the outset that this video should not be taken as legal advice, and you must not rely upon it. It is a general explanation of what the search warrants are, the application, and the information required in a warrant. You must always seek formal legal advice, especially if you are intending to challenge any warrant issued to search your premises. But with that said, if you're new to me and my channel, I'm a barrister who helps you understand law, so feel free to leave your questions and comments here, and I might get to them over at Black Belt Secrets, my sister channel linked below, so please make sure you subscribe there as well. I'm going to talk about a couple of different types of search warrants, including the application for them and what information is required. I will also answer the question as to whether a warrant needs what is known as a wet signature to be valid. A wet signature is that which is penned by hand in real ink and is an original copy, so make sure you stay to the end of the video. So as I said, Section 8 of PACE is a fairly general power to obtain a search warrant, to search for evidence of indictable offences. But as I said, there are over 175 different statutory provisions that provide for the application of a search warrant. For example, in TV licensing, a search warrant would be sought under Part 4, Section 366 of the Communications Act 2003. Many of these statutory provisions, such as this one I've mentioned, will provide for who is able to make the application for a search warrant and what it is that that search warrant will be specifically looking for. In other words, it won't be a general power to search the entire premises for anything that they like. It must be limited to that specific search, and this is something that I'm going to come on to when talking about the information and the application. And because a search is most definitely an invasion of privacy, it should necessarily be limited to the extent and the scope and the purposes of the search for what the officer reasonably believes they are going to find. Looking at a Section 8 search warrant by way of example, this is a search warrant to look for evidence of an indictable offence, and this could be a specific premises warrant or an all premises warrant. And this means exactly what it sounds like. It could be limited to that specific premises that is listed on the warrant, or it could be all premises that belong to the person named in the warrant, whether those be occupied or controlled by said person. And premises is defined very broadly. It is not limited to buildings. It could include vehicles, aircraft, vessels, and even a tent. The standard grounds for obtaining a warrant are broadly fourfold, and the first two are quite similar. Firstly, that it would not be practicable to communicate with the person entitled to grant entry to the premises, or alternatively, the person who is entitled to grant access to the evidence that is sought. Thirdly, and probably most commonly, is that entry is not likely to be granted but for the issue and production of a search warrant. Fourthly, and probably most common in serious offences, that the purposes of a search is most likely to be frustrated or prejudiced but for the fact that a constable turns up and gains immediate entry to conduct the search. In other words, somebody could dispose of evidence before it's discovered. An application for a warrant under Section 8 must demonstrate reasonable grounds for believing that firstly, an indictable offence has been committed, secondly, that there will be evidence of significant value on the premises, and thirdly, that the material is evidence that is likely to be relevant and admissible for trial for that offence. When looking at such an application, the magistrate or judge must not only be convinced of these things, but also that the material is not likely to be legally privileged or any other kind of excluded material that would not be permissible under a search warrant. There is also a duty of full disclosure on any person making an application. This means that if any information is left out of that application, which if included might have led to the refusal of the application, then the warrant will become invalid. As you can imagine, this is a fairly in-depth discussion which could take an entire video by itself. So the warrant, and therefore the application, must specify, so far as is practicable, the articles or indeed persons that are sought during that search, and this is provided in what's called an information. An information is simply a document that contains all of the information upon which this application is going to be decided. Much like the beginnings of a prosecution, where an information is laid before the magistrate to decide whether on the facts there is the scope for a prosecution. But in this case, an information is laid with the application for the purposes of a search warrant. And the simple effect and result of this information being defective is that the search itself can end up being ruled unlawful. Just as in the Sweeney and Magistrates Court case of 2014, a search was appealed on the basis that it was unlawful because the information was defective in a number of ways. Firstly, that it failed to set out the statutory requirements, which is of course a requirement for a search warrant to be granted. And following on, it failed to set out the facts that would have supported those statutory requirements. It failed to identify the offences with reference to the facts. It failed to make full and frank disclosure about information known to the person making the application. And along with a list of other reasons, the warrant was found to be defective and therefore the search was found to be unlawful. As to how the search itself will be conducted, this might depend on the search itself, the purposes, and which statutory provision the search warrant was obtained under. For example, a Section 8 search is going to be with an officer or many officers, whereas a search authorised under the Communications Act 2003 for the purposes of a TV licence may be one or more persons authorised by Ofcom or the BBC and may or may not be in the company of a police officer. And using a search for the purposes of TV licensing by way of example, this is specific and limited to the testing and examining of any television receiver found during the search, which, if you remember my previous videos, this is fairly specifically defined. And this is that a television receiver means any apparatus installed or used for the purpose of receiving any television program service, any on-demand program service provided by the BBC, in other words, BBC iPlayer, whether or not the apparatus is installed for any other purpose. Now, whilst this test might not appear difficult to overcome, from my point of view, it is certainly not without challenge, because the specific wording of the Act indicates that there is an intention on the part of the person who installed said television receiver that he or she did so for the purposes of receiving a live television programme or on-demand BBC service. If such a person were to say that that was not the intention of installing the equipment, the Act then requires both the application for the warrant itself, and the person executing the warrant to override what this person is saying, i.e. that they did not install this equipment for the purposes of watching or recording live TV or on-demand BBC services. For example, think of the situation where you have a TV installed at home and you only use it for DVDs, YouTube, games, and so on, but you do not intend and you did not install it for the purposes of watching or recording live TV or BBC iPlayer, then you have not installed that equipment for those purposes. Therefore, under the definition of the Act, it is not a television receiver. Although, of course, if that was just one of the purposes, even if you use it for other purposes, then of course it is still a television receiver for the purposes of the Act. So in my point of view, this is an area open to challenge. Upon arrival at the premises, the person executing the warrant must produce it to the occupier. This isn't just showing it to the occupier so that they can see that it is a warrant of some sort. Producing means that they are given an opportunity to examine it, to check the details, what the purpose of the search is, and so on. And in doing so, you should look for all of the following information. Checking carefully the date of issue, because it must be conducted within 3 months. The scope of the warrant and any documents that are authorised to be seized under such a search. The name of any person or organisation that is the subject of any investigation. The address at which the investigation is to take place. Names of any investigators. Of course, the court that issued the warrant. And any reasons that are stated for authorising entry or access to the premises. Then, of course, you should observe the full search very carefully. There is nothing against you filming this on your phone to create a full record of exactly what happens during the search, because if either the warrant itself or the search become defective, then it may well render that search unlawful, at which point obviously you must seek formal legal advice. So that is a broad overview of search warrants and the application and the information required for them. But as promised, The question that I see in many different places is as to whether a search warrant is required to have a wet signature. A wet signature being an ink signature on a page on an original document produced during the search. This is not a requirement. In fact, the West London Magistrates Bench is a dedicated search warrant court, and on receiving, usually electronically, an application for a warrant, if granted, an electronic signature is added to the warrant and it's returned to the applicant. Although usually these will have the court stamp, and the rules require that there's an indication, whether by signature or otherwise, that it's been approved by the court. So I hope you found that video useful. Please give it a big thumbs up if you like videos like this, and remember, stay humble and subscribe.